Good afternoon and welcome to the next installment of Secrest Wardle's COVID-19 webinar series, COVID-19 and Commercial General Liability Coverage, the Emerging Battleground. In the first two installments of our web series, we focused on the battle between insureds and insurers over whether there is coverage for alleged business interruption losses due to COVID-19. But we now want to shift the focus to what we anticipate will be the next battleground in COVID-19 litigation: coverage under a commercial general liability policy. At the outset, let me preface this by saying we have yet to see how courts will ultimately decide whether there is coverage under a commercial general liability policy, as these types of disputes are in their infancy. Also, I want to remind everyone, when evaluating coverage, it is vital to review the insured's specific policy and the entire policy. To say that 2020 has been a year like no other is, at this point, a gross understatement. Nearly every sector, public and private, has been impacted by the human and economic consequences of COVID-19. The insurance industry is no exception, as policyholders are, perhaps for the very first time, discovering what insurance coverages are and are not available. Thus far, the disputes have centered on the insured and the insurer and continue to primarily focus on first-party coverages for alleged business interruption losses. This is not surprising given the timeline to date. In the wake of the declaration of a national emergency, individual states not only declared emergencies, but imposed restrictions on their residents and businesses in an effort to mitigate the spread of COVID-19. As a consequence, businesses began to turn to their insurers to cover business interruption losses. Given the initial financial impact was related to a suspension of business operations, the first coverage fight was far from unexpected. Moving on, as our state and our nation begin to ease restrictions and businesses begin welcoming patrons back to their brick-and-mortar establishments, it brings with it the possibility of new insurance claims. These claims, however, relate to a policyholder's potential liability to patrons, guests, vendors, and other third parties over exposure to COVID-19 and whether a business owner may owe a duty of care to protect them. The year 2020 and COVID-19 have presented the insurance industry with a myriad of novel issues and factual scenarios of first impression. Whether these previously unimaginable factual scenarios will trigger coverage will be litigated for years to come. While the facts will vary, we anticipate general circumstances in which coverage may be sought under a general liability policy to fall into the following general scenarios. An insured caused a patron's harm by failing to exercise reasonable care in implementing protocols to safeguard against COVID-19 exposure. Or there's a potential for claims involving allegations an insured caused a patron's harm by failing to exercise reasonable care in enforcing established guidelines and standards. Additionally, we also anticipate claims related to allegations an insured caused a patron's harm by failing to exercise reasonable care in taking steps to close their establishment and diligently clean after learning of exposure, whether potential or actual, by an infected individual. In the context of general liability coverage, one of the first questions that will be asked is whether the policyholder owed a duty to a patron, guest, or other third party. Now, notwithstanding the uncharted waters COVID-19 has presented and will continue to present, the first deterrent for potential plaintiffs should be whether a premises possessor even owed a duty to protect them from being exposed to or contracting COVID-19. At this early stage, we do not know the definitive answer, but Michigan law does provide some context. A recent case out of the U.S. District Court for the Eastern District of Michigan, in Flint water cases, recently held that Michigan law does recognize a duty to take at least some measures to prevent the spread of a communicable disease. and that duty sounds in premises liability. In April of 2020, the United States District Court for the Eastern District of Michigan held a plaintiff had a viable cause of action against a local hospital based on a patient allegedly contracting Legionnaire's disease from the hospital's use of Flint water. For those of you that don't know, Legionnaire's disease is a severe type of pneumonia that individuals can contract if they breathe in water droplets containing the bacteria, or if otherwise contaminated water enters their lungs while drinking. On an initial basis, you can already see how this case might provide some guidance. In the court's opinion, the court held that the cause of action sounded in premises liability as opposed to ordinary negligence. The court held this was true even where a plaintiff alleges that the premises possessor created the condition by giving rise to the plaintiff's injury. Although this case suggests that a premises possessor may have a duty to protect people who are entering their premises from exposure to COVID-19, that does not mean the plaintiff will necessarily recover, as duty in a premises case is conditioned on both possession and control. Under Michigan law, possessor is defined as a person who is in occupation of the land with the intent to control it, or a person who has been in occupation of the land with intent to control it, if no other person has subsequently occupied it. A possessor is also defined under Michigan law to include a person who is entitled to immediate occupation of the land. Control, on the other hand, has been defined as exercising restraint, direction over, dominate, regulate, or command. Again, for the purposes of duty under a premises liability case, the defendant must have both possession and control. Additionally, duty depends on status. By now, we are all familiar with the three statuses a visitor may have, whether it be a trespasser, a licensee, or an invitee. It is unlikely in the context of general liability claims we are going to be dealing with a trespasser. Rather, we're likely going to be dealing with a licensee or an invitee. Now, a licensee is a person who is privileged to enter the land of another by virtue of the possessor's consent. On the other hand, an invitee, to whom we owe the highest standard of care, is a person who enters upon the land of another by an invitation, and that invitation carries with it an implied representation or assurance that reasonable care has been taken to prepare the premises and make it safe for that invitee. Now, going back to the recent decision in the Flint water cases, the court held the patient was considered an invitee because they were at the hospital for a business purpose. Once we are able to discern the potential status of the claimant, we need to understand how that status relates to the duty owed. As for a licensee, a landowner only owes a licensee the duty to warn of any hidden dangers that the premises possessor knows or has reason to know of if the licensee does not know or haven't reason to know of. Importantly, if a patron is considered a licensee, the premises possessor has no duty of inspection or affirmative care to make the premises safe for that licensee's visit. Typically, social guests are included within the definition of licensee. Contrast that now with what is an invitee. If the patron is considered an invitee, then the landowner has the highest duty of care, including not only the duty to warn the invitee of any known dangers, but an additional obligation to make the premises safe, which requires the premises owner to inspect the premises and, depending on the circumstances, make any necessary repairs or to warn of any discovered hazards. It is notable the plaintiff in the Flint water cases alleged the hospital was aware that there was a significant increase in the number of fatal and non-fatal cases of Legionnaire's disease that coincided with the introduction of Flint River water as a drinking source for Flint residents. The plaintiff further alleged that the hospital had sufficient knowledge of the risks associated with exposure to Legionella bacteria stemming from the use of Flint water. Now, it's important to recognize that the U.S. District Court for the Eastern District of Michigan rendered its decision under Federal Rule 12b-6 and not Federal Rule 56c, and therefore the opinion only addresses whether notice was adequately pled and does not address what evidence would have been needed to prove adequate notice. In turning to the very issue of notice, we anticipate claimants will assert that a premises possessor, such as a store owner, had notice of COVID-19 because of its widespread occurrences. But that COVID-19 may be in the ether or is otherwise presumed to be everywhere does not necessarily place a property possessor on notice that COVID-19 is actually present in their particular store. Claimants are going to have to be able to identify specific instances of an infected person being present on the insured premises to satisfy this burden. Further, claimants are going to have to show there was some basis to believe if COVID was present but not known to the premises possessor, its presence could have been discovered upon a closer investigation. Michigan law requires that a prima facie case of premises liability include sufficient evidence that the landowner either created the dangerous condition or had actual or constructive notice of the dangerous condition. Constructive notice generally requires evidence that the condition existed for a sufficient period of time and that a reasonable premises possessor would have discovered it. Thus, we anticipate that potential claimants are going to assert, based on the widespread nature of COVID-19, the premises possessor had constructive notice. While we anticipate that any general liability claims will properly be framed as premises liability claims and provide the best chance of success when framed as a premises liability claim, we do anticipate that claimants will attempt to present these claims framed as ordinary negligence. Generally speaking, while every person who is engaged in the performance of an undertaking has the duty to use due care and not unreasonably endanger others, we must recognize in Michigan there is no duty that obligates one person to protect another. With regard to ordinary negligence, the ultimate inquiry in determining whether a legal duty should be imposed is whether the social benefits of imposing that duty outweigh the social costs. Factors relevant to the determination of whether a legal duty exists include the relationship of the parties, the foreseeability of the harm, the burden on the defendant, and the nature of the risk presented. When there's no relationship between the parties, no duty can be imposed. And generally, even when there is a relationship between the parties, a legal duty does not necessarily exist. Perhaps more importantly to the anticipated liability claims is the fact that the mere occurrence of an injury or event that is foreseeable is not necessarily sufficient to impose a duty. The question is, at base, in light of all the relevant evidence, is the defendant under any obligation for the benefit of this particular plaintiff? Now, one of the key things that we must be considering is whether a policyholder can actively assume a duty. As the reopening begins and a lot of businesses are advertising they follow CDC and similar guidance in an attempt to lure their patrons back, the question that flows from this is whether there has been a voluntary assumption of a duty that may permit a cause of action for failing to comply. Now, Michigan law does incorporate the voluntary assumption of duty doctrine, which holds if you assume to act and you do so negligently, liability may exist to third parties for the failure to exercise care and skill in acting. More simply put, if one voluntarily undertakes to perform an act, having no prior obligation to do so, then a duty may arise to perform the act in a non-negligent manner. We note that voluntarily adopting industry customs or guidelines, such as internal guidance, does not necessarily establish those guidelines as the tort standard of care. The question of whether external guidelines, such as those promulgated by the CDC or similar bodies, set the tort standard of care is an entirely different question. A violation of a safety statute, for instance, creates a rebuttable presumption of negligence. In that same vein, a violation of an ordinance, if proven, can be evidence of negligence. However, take for example the fact that violations of Michigan's Occupational Safety and Health Act, for example, do not set a tort standard of care because of the specific language of the Act. Specifically, MIOSHA states that its standards do not enlarge or diminish or affect any other manner of the common law, statutory rights, duties, or liabilities of employers and employees under any law with respect to injuries, disease, or death arising out of or in the course and scope of employment. In determining whether a statutory violation is relevant to the facts presented, the court must consider the following factors. 1. The statute is intended to protect against the result of the violation. 2. The plaintiff is within the class intended to be protected by the statute. And 3. The evidence will support a finding that the violation was, in fact, the proximate contributing cause. Where all these factors are met, the violation of a safety statute would be admissible as evidence, creating a rebuttable presumption of negligence, even though the statute does not directly apply to the type of action at issue. In the context of COVID-19, trying to use CDC or other federal, state, or local guidance as a tort standard will be difficult, as the medical experts and public health officials do not always agree with one another on all the issues related to COVID-19. And inasmuch as some seem to have reversed themselves on various issues over time, there is still largely disagreement. On July 29, 2020, the United States District Court for the Middle District of Tennessee issued an opinion in United States v. Walker, which provides some guidance as to how courts may use CDC or other guidance. In that opinion, the court held relying on information and opinions regarding the prevalence of, effect of, and optimal countermeasures to COVID-19 have been in constant flux, and it would be folly for the court to rely blindly on any particular opinion or factual assertion merely because it comes from a purportedly knowledgeable or reputable source. The court went on to state it seems clear that certain public health authorities, public health officials, and other public officials over time have equivocated regarding or even starkly changing their views concerning one or more of the numerous issues, including whether COVID-19 can be transmitted person to person, whether persons should avoid crowds or otherwise alter their daily regime to mitigate the spread of COVID-19, as well as the extent to which COVID-19 may be transmitted via contact with inanimate surfaces. Thus, if we look to the United States District Court for the Middle District of Tennessee for insight and guidance, at least this opinion would suggest that guidance issued by the CDC and other public health agencies will likely not be used to set the tort basis for liability. Now that we know it is possible that claimants will seek to hold policyholders liable for COVID-19 exposure, we turn to the question of whether liability coverage may be available. At the outset, we must understand that general liability coverage is designed to provide coverage to businesses and individuals against third-party claims. If coverage is triggered, the insurer is obligated to defend and potentially indemnify its insured against the third-party claims. Thus, as suits are filed and insureds turn to their commercial general liability insurers for coverage, the insurer must carefully consider if there is coverage in the first place, and if so, whether any exclusions may apply to bar that coverage. Traditional commercial general liability policies provide coverage for bodily injuries caused by an occurrence. Therefore, we must answer the following question: was there a bodily injury caused by an occurrence? And in making this determination, we turn both to the policy and the complaint. One of the first questions that will be required to be answered in evaluating whether there's liability coverage is whether COVID-19 is a bodily injury as defined by the policy. At first blush, whether COVID-19 is considered a bodily injury may seem like an illogical question, but where insurance coverage is concerned, how a policy defines a term is essential to determining coverage. Bodily injury is a defined term for most commercial general liability policies. Bodily injury is defined in one ISO form as physical injury, sickness, or disease sustained by a person, including the resulting death of that person. From what we have seen and what we know about the physical effects of COVID-19, it would seem that COVID-19 would clearly fall within the definition of bodily injury. And to the extent a complaint asserts that the claimant did sustain physical injury, sickness, or other physical symptoms as a result, there likely has been a bodily injury as defined by the policy. The question becomes more difficult when the allegations of the underlying complaint detail claims of mental anguish, anxiety, emotional pain and suffering, and fail to allege any physical symptomology. In the context of evaluating coverage where the underlying complaint presents allegations of mere mental anguish and other emotional injuries, the question becomes more detailed. The Michigan Court of Appeals has been asked to consider whether emotional injuries constitute bodily injury for the purposes of general liability coverage. In finding in favor of an insurer and declining to expand the definition of bodily injury to include allegations of mental and emotional injuries, the Court of Appeals has interpreted the phrase bodily injury, sickness, or disease to require at least some physical manifestation of the mental injuries. Thus, standing alone, it is unlikely a complaint which alleges bodily injury based on mental and emotional injuries alone would be sufficient to trigger coverage. However, most claimants allege both physical injuries as well as mental and emotional injuries, and therefore it's important to fully review the underlying complaint in detail to determine just what kind of injuries the claimant is alleging. Moving on, and assuming the underlying complaint has alleged sufficient bodily injuries, the next inquiry is whether those bodily injuries were caused by an occurrence. Most standard ISO general liability forms define an occurrence as an accident, including continuous or repeated exposure to substantially the same general harmful conditions. So, what exactly is an accident? Well, the Michigan Court of Appeals has defined an accident as an unsigned contingency, a casualty, a happening by chance or something out of the usual course of things, that which is unusual, fortuitous, not anticipated, and not naturally to be expected. As it turns out, The word accident is one of the oldest and most litigated words with respect to coverage. Perhaps there is no better summation of just how difficult concluding what is and is not an accident was provided by Justice Musmano in Brennerman v. St. Paul Fire and Marine Casualty Company. He included in his opinion the following soliloquy. What is an accident? Everyone knows what an accident is until the word comes up in court. Then it becomes a mysterious phenomenon, and in order to resolve the enigma, witnesses are summoned, experts testify, lawyers argue, treatises are consulted, and even when a conclave of 12 world-knowledgeable individuals agree as to whether a certain set of facts has made out of an accident, the question may not yet be settled and must be re-litigated in an appellate court. His comments show just how difficult it is to really determine whether something is or is not an accident. Whether we have an occurrence is a very fact-intensive inquiry. It's important to note that an accident is evaluated from the standpoint of the insured and not those that are harmed by the alleged action or inaction. Therefore, in the context of evaluating coverage under a general liability claim brought by a patron or another third party who alleges to have been exposed to or contracted COVID-19 in their establishment, whether it was caused by an accident will be judged by the foreseeability of the aggrieved party's injury. And it's important to note the appropriate focus of the term accident must be both on the injury-causing event and its relationship to the resulting injury. To this end, when the claim is alleged to have occurred, will likely make a difference in considering whether there has been an occurrence for the purposes of liability coverage. This goes back to foreseeability. Just compare what we knew about how to mitigate and prevent the spread of COVID-19 in March 2020 versus June 2020 and today. Thus, for purposes of evaluating coverage, what was known about the transmission of COVID-19, the business's practices in mitigating the risk of exposure to its patrons and other third parties, and whether that business was diligent in adhering to and enforcing the best practices will all come into play. Another consideration when evaluating liability coverage based on the claim a patron was exposed to COVID-19 while at the insured's premises, some consideration must be given to whether exposure would constitute a single or multiple occurrence. This is especially true where certain types of businesses, where a single individual may have contact with multiple patrons or customers on a single day, or there are multiple claims alleged to have been associated with the same exposure event. Now, think about this in a context of an essential business where a worker who is discovered later to have contracted COVID-19 had contact the previous day with 10, 50, or 100 people over the course of their last shift. Now, while initially we would think that several people exposed or even exposure over the course of a day at the same location would constitute a separate occurrence for each exposure and each individual, that's not necessarily the case. A survey of national case law reveals certain circumstances, including Hurricane Katrina, wherein the courts held all hurricane-related damage, despite the fact homes were damaged at different times and ultimately raised at different times by the local authorities, all constituted a single occurrence. A similar single occurrence result was reached relative to the attacks on the World Trade Centers in 2001. Thus, it's especially important to evaluate whether we have one or more occurrences. Most general liability policies hold that all occurrences relate back to the initial event, but that is not necessarily going to be the case when we're talking about alleged bodily injury as a result of COVID-19 exposure. Another thing that we must consider is what happens if claims are presented over a period of time against the same policyholder, but the insurers have changed. Is one insurer potentially liable for all the alleged occurrences even after their policy terminated? Well, the answer is generally no. Under Michigan law, when coverage is triggered under multiple successive insurance policies by injuries occurring over multiple policy terms, coverage is actually apportioned based on a time on the risk approach. Now, assuming that the underlying complaint in fact does set forth a bodily injury caused by an occurrence, the coverage insurer's next inquiry will be whether an exclusion bars coverage. The fact that coverage is triggered on an initial basis is not tantamount to a guarantee of coverage. Exclusions to coverage must still be considered. Most standard ISO general liability forms and endorsements contain several exclusions which are likely to become the subject of extensive litigation as COVID-19 exposure claims begin to be filed. Generally, we anticipate the following exclusions will likely be the subject of litigation. The exclusion for bodily injury which is expected or intended. The communicable disease exclusion, which can be found either in the base coverage or in an endorsement. The pollution exclusion, and the exclusions for workers' compensation and employer liability. It's important to note that sometimes an exclusion may be found in endorsement. Now, endorsements by their very nature are designed to take precedent over general policy provisions, and where a conflict exists between the provisions of the main policy and an endorsement, the endorsement will prevail. The first exclusion, which we anticipate will be the subject of intensive coverage litigation, is the exclusion for bodily injuries which are expected or intended from the standpoint of the insured. Inclusion of the words expected and intended result in a broadening of the exclusion. Michigan courts have recognized that the term expected in the context of this particular exclusion means natural, foreseeable, and the expected and anticipated result of an intentional act. The Michigan Supreme Court has applied this exclusion to bar coverage for injuries caused by an insured who acted intentionally despite his or her awareness that harm was likely to follow from the conduct. This will be particularly important for the purposes of COVID-19 related claims. The Michigan Supreme Court has also held this exclusion bars coverage if the insured's claim that he or she did not intend or expect the injury flies in the face of all reason, common sense, and experience. It's easy to see why this exclusion may be attractive to an insurer evaluating coverage. Especially true if, for example, the facts pled in the underlying complaint indicate the policyholder was perhaps aware an employee who had contracted COVID-19 or was experiencing symptoms was still allowed to work and come in close contact with patrons. In dealing with the expected or intended exclusion, it's important to understand this is a very subjective standard. As the Michigan Court of Appeals has recognized, the question is not whether a reasonable person would have expected the consequences, but whether the insured reasonably should have expected the consequences. Michigan courts have also recognized in precluding coverage when an insured's intentional actions create a direct risk of harm. There can be no liability coverage for any resulting injury despite the lack of actual intent to injure. The pertinent determination that must be made is whether the consequences of the insured's intentional act were either intended by the insured or reasonably should have been expected because of the direct risk of harm intentionally created by the insured's action. This same language bars recovery for damages and injuries that reasonably should have been expected because of the direct risk of harm intentionally created by the insured's action. This all goes back to the foreseeability of the injury. However, it does remain uncertain as to whether this exclusion will be given widespread effect in the context of COVID-19 claims. The next exclusion we anticipate will be at the heart of coverage litigation regarding liability claims is the communicable disease exclusion. Some policies include this exclusion within the main policy, and others include this exclusion in a standalone endorsement. Regardless of where it's found, the communicable disease exclusion excludes coverage for claims involving bodily injuries that arise out of or otherwise result from the transmission of a communicable disease. The next question then is whether COVID-19 will be considered a communicable disease. And at this point, no court has addressed the issue. As an initial matter, one may question whether COVID-19 is a virus or a disease. Scientifically, the World Health Organization has identified the virus as SARS-CoV-2, while its effect, the actual disease, as COVID-19. As a result, the distinction between SARS-CoV-2 and COVID-19 is likely a distinction without a difference for the purposes of coverage. It's also important to note, not all policies include this exclusion, whether in the main form or as a standalone endorsement. Again, it's very important to review the complete policy with all forms and endorsements before rendering a coverage determination. This exclusion also raises an interesting issue in terms of causation and whether a claimant would ultimately be able to prove they actually contracted COVID-19 at the policyholder's establishment versus another on a particular day. That said, when evaluating coverage, we look to the allegations of the complaint, and therefore we are forced to set the issues of causation aside. Another exclusion where we anticipate will be a battleground for coverage litigation is the pollution exclusion. Standard general liability policies, including most ISO forms, include an exclusion for bodily injury which results from the alleged or threatened discharge, dispersal, seepage, migration, release, or escape of pollutants. This begs the question, what is a pollutant? Most general liability policies define pollutants as any solid, liquid, gaseous, or thermal irritant or contaminant, including smoke, vapor, soot, fumes, acid, alkalis, chemicals, or wastes. So is COVID-19 a pollutant? The question remains unsettled. Some states have limited the exclusion to what we think of as traditional environmental contamination. But Michigan has adopted a much broader reading. Michigan is within the minority with respect to how it defines and applies pollutant, as there's case law holding the pollution exclusion is not limited to traditional environmental pollutants. The scope of the total pollution exclusion has been repeatedly litigated, spawning conflicting judicial decisions throughout the country. States generally fall into one of two camps. Some courts apply the exclusion literally, finding the term to be clear and unambiguous. Other courts have limited the exclusion to circumstances involving traditional environmental pollution, generally because the term is either held to be ambiguous or because they find the exclusion contradicts a policyholder's reasonable expectations. Here in Michigan, we fall within the broader reading that the exclusion applies literally and extends beyond what we think of as traditional environmental pollutants. We also note that Michigan does not recognize the principle of reasonable expectations in the context of insurance coverage, and insureds are obligated to read their policies. In other words, based on the current case law in Michigan, there's no reason why COVID-19 could not be considered a pollutant. A virus could also be considered a contaminant, which is included within most policy definitions of pollutant. In Michigan, a contaminant is simply something that contaminates. In the context of the pollution exclusion, specifically, the Michigan Supreme Court has defined contaminants as to make impure or unsuitable by contact, to pollute or taint. Thus, there's a legitimate argument that could be made that a virus, including COVID-19, is a contaminant, but Michigan has not reached this specific issue yet. The last exclusion where we anticipate COVID-19 to be litigated for the purposes of liability coverage is in the context of employer's liability. Most general liability policies exclude coverage for any obligation an insured may have under the state's laws relating to bodily injury arising out of the course and scope of employment. Most of these workers' compensation and employer liability exclusions also act to bar coverage to an employee's spouse, child, or parent. Here in Michigan, presenting a workers' compensation claim with the agency for bodily injury or occupational disease sustained in the course and scope of employment is generally the exclusive remedy. Relative to COVID-19, employment situations are going to likely be covered under the exclusive remedy provision of the Workers' Compensation Disability Act. The one exception is for an intentional tort. Under Michigan's Workers' Compensation Disability Act, an intentional tort exists only where an employee is injured as a result of a deliberate act of the employer, and the employer specifically intended the injury. It's important to note, because this may seem attractive in the context of COVID-19 and the well-publicized claims employers are not doing what they need to protect their employees. Under the Act, an employer shall be deemed to have intended the injury if the employer had actual knowledge that the injury was certain to occur and willfully disregarded that knowledge. Now, we do anticipate, in the context of the employer-employee paradigm, we will see liability claims filed in circuit court alleging an intentional act and the attempt to circumvent the exclusive remedy provision. But it's important to note the issue of whether an act was an intentional tort is a question of law for the court, and this presents a very high burden for claimants. In order to invoke this exception, a claimant has to establish the employer deliberately acted or failed to act with the purpose of inflicting the injury upon the employee. So nearly all work-related COVID-19 exposures are going to be dealt with through the Workers' Disability Compensation Act and not general liability claims. Again, we must be cognizant, however, depending on the allegations in the underlying complaint, this exclusion standing alone may not be sufficient to bar coverage for defense. So now we must begin to talk about an insurer's obligation under the policy. Whether an insurer has a duty to defend under a liability policy is assessed by reference to the underlying complaint and the specific terms and conditions of the policy. The focus is not on the headings or the inartful nomenclature, but on the specific allegations reading the complaint as a whole. It is the substance of the allegations from which the insurer must examine coverage, not the form. The terminology chosen by the claimant is not dispositive. Thus, we must be focusing on the basis for the injury and not the headings or nomenclature of the underlying complaint in order to determine whether coverage exists. This requires us to look at the individual allegations to determine their substance as opposed to their mere form. As discussed above and in more detail, a claim framed in the context of a premises liability action has a much better chance of success on the merits than an ordinary negligence claim. However, for the purposes of coverage, we are required to look past the headings or titles to the allegations themselves. There are certain coverage principles that have emerged from decades of coverage battle. The insurer only has a duty to defend the insured if the charges against the insured arguably fall within the language of the policy. An insurer has an obligation to defend the insured if there are any theories of recovery which fall within the policy's scope of coverage, even if some other theories of liability are not covered. Thus, if any one single count triggers the insurer's obligation to provide defense, the insurer must defend as to all counts. The Michigan courts have recognized that if the allegations of the third party against the policyholder even arguably come within the policy coverage, the insurer must provide a defense. This is true even where the claims may be groundless, meritless, or frivolous. In talking about the extent to which defense must be provided, insurers owe a duty to defend the insured until there is no recovery possible under the policy. This is why, for the purposes of evaluating coverage, the merits and ultimate viability of the claims are not considered. We recognize that proximate causation is going to be the largest defense for any claim. Specifically, can the claimant actually prove they were exposed to or otherwise contracted COVID-19 at the policyholder's premises? But for the purposes of evaluating coverage in the first place, proximate causation is not a consideration. Perhaps more importantly, any doubt as to whether there is even a remote potential for coverage under the policy will be resolved in favor of the insured and will mandate a continuing defense. But defense does not always equal indemnity. There's a common misconception that if coverage is triggered and an insurer has an obligation to provide a defense, ultimately that insurer will also have to provide indemnity. But this is not always the case. The duty to defend is broader than the duty to indemnify. This is what distinguishes the duty to defend from the insurer's ultimate duty to indemnify. The duty to defend exists wherever a third party's allegation arguably qualifies for coverage. But the duty to indemnify exists only where the third party's allegations have been proven true, or when, after significant factual development, the insurer and the insured decide to settle a claim rather than test its ultimate veracity in court. Thus, while the duty to defend extends to claims which arguably fall outside the scope of coverage, the duty to indemnify extends only to those covered claims. As insurers begin to evaluate coverage under their liability policies, it's important to recognize that declining coverage comes with risk. While the initial burden to show there is coverage for a claim lies with the insured, an insurer bears the lofty burden of proving an exclusion bars liability coverage. Yes, clear and specific exclusions must be given effect, and coverage is lost if any exclusion applies to the claims. But because exclusionary clauses excuse an insurer from liability, and because of the serious implications of the same, exclusions are strictly construed in favor of the insured. This is why the courts have recognized time and time again that any contractual language limiting an insurer's liability must be unambiguous, otherwise it will be deemed unenforceable. Because of the risks associated with declining coverage, an insurer's obligation to provide defense is an exacting standard by any measure. Insurers can only escape their obligations to defend liability claims only if the policy precludes any colorable interpretation which would permit coverage. There is a very high price for declining coverage if it's later determined that the insurer breached its obligations. In fact, Michigan law mandates any doubt over whether the policy even arguably provides coverage be resolved in the insured's favor. If the insurer is ultimately held to have breached its obligations to defend under the policy, the insurer will become liable not only for reasonable good faith settlements paid by the insured, but defense costs as well. Now, at this point, you might be recalling that most commercial general liability policies include conditions in the event of a claim or suit that precludes an insured from settling claims without the insurer's consent, and asking whether this condition can still be invoked by an insurer to avoid payments or settlements. If the insurer has declined to provide defense, the answer is generally no. The Michigan courts have held where an insurer declines defense and leaves the insured personally exposed, only later to be determined that it breached its duties to defend. The insurer cannot rely on the conditions to avoid payment. This is because the insurer could have defended under a reservation of rights, engaged in settlement discussions, evaluated its risk, and chose not to. By choosing not to defend under a reservation of rights and declining its obligations to defend fully, it cannot later rely upon the conditions of the policy it's determined to have been breached. Thus, as you are evaluating whether there is coverage for defense, an insurer must be cognizant of the potential risks it faces should it decline coverage completely. Because COVID-19 will present issues of first impression for general liability insurers, insurers are cautioned to recognize a firm coverage decision may not be possible at the time of filing based on the allegations contained in the complaint. For insurers faced with deciding if a claim against its policyholder related to COVID-19 triggers coverage, the insurer should do its due diligence in investigating the claim, including a full review of the policy alongside the complaint before making any decisions to decline. If coverage is questionable, insurers should consider providing a defense under a reservation of rights and filing a declaratory judgment action seeking a formal coverage determination. It's important to recognize as insurers begin evaluating liability coverage, insurers are not permitted to look to extrinsic evidence which may suggest or otherwise negate against coverage. A coverage decision must be based on the well-pled allegations of the complaint and accepting all of the same as true. This is certainly an uncertain time. Regardless of the legal and factual challenges plaintiffs will face in proceeding with litigation, and perhaps what may be a shared belief between the insurer and the insured that the claims are frivolous, an insurer must recognize the ultimate merits and veracity of the allegations are not part of a coverage consideration. While we can look to how the courts have decided similar coverage issues when presented with previously unthinkable events, such as the attacks on the World Trade Center and Pentagon and historic natural disasters, the true consequences of COVID-19 remain uncertain and challenge us to rethink what is possible. This will force insurers to look at the policy in a new frame of reference. Another consideration, perhaps as to liability, will be waivers. There's been a lot of discussion about legislation limiting liability exposure for certain industries as reopening continues. But for most businesses, legislative immunity will not be immediately forthcoming. And as a result, many business owners are looking to liability waivers in an attempt to reduce the risk. So if there is a waiver, will that affect an insurer's coverage obligation? Perhaps. In Michigan, liability waivers are permissible and potentially could provide a policyholder with a strong defense against a bodily injury claim. But that does not affect the coverage decision. Recall, whether there's coverage is initially viewed in the context of the policy and the allegations of the complaint. Thus, the fact that a waiver may ultimately preclude a claimant's recovery is not considered. Unlike business interruption claims, which are swiftly becoming part of the everyday conversation as they related to the closures of businesses, in the immediate aftermath of the declaration of emergency and limits on non-essential businesses. General liability claims are just beginning to emerge. This is the anticipated and natural progression as businesses have just recently begun welcoming back patrons. It is this reopening upon which the general liability coverage battleground is placed. It's only a matter of time before the courts will begin deciding if COVID-19 exposure can constitute an occurrence. As the reopening continues, it's important for insurers to develop a plan of attack. While COVID-19 remains novel, an insurer can develop a sound strategy for evaluating coverage now. When a claim is filed, the insurer should request a complete copy of the complaint and all its exhibits. And then the insurer should review the entire policy, including all amendments, endorsements, and following forms, in truly evaluating coverage. If, in reviewing the complaint and the policy, there is even an arguable basis for coverage, and or at least one claim is within the scope of coverage, the insurer should assign defense under a reservation, send a detailed reservation of rights letter to the insured, preserving its rights to investigate and contest coverage, and if the insurer truly believes there's no coverage or an exclusion precludes coverage, the insurer should file a declaratory judgment action and seek a formal court ruling. Again, as we continue to move through these unprecedented times, insurers need to be proactive in considering what types of coverages may be implicated by COVID-19. While the initial coverage sought may have been first-party coverages and related to business interruption losses, general liability insurers will soon be facing the same challenges as to evaluating whether novel factual scenarios associated with COVID-19 trigger coverage. While general liability claims associated with COVID-19 are currently in their infancy and have not been tested within the judicial arena, it is on the horizon. Thus, insurers must begin considering the novel issues that will be presented when COVID-19 and liability policies collide. Thank you for attending Secrest Wardle's COVID-19 webinar series, and specifically today's conversation regarding COVID-19 and commercial general liability claims, the emerging battleground. Should you have any questions or comments, please do not hesitate to contact us directly